Okay, so we'll go ahead and get started. I'm Sheena. I joined the firm in November of 2018, which I'm in the Atlanta office, so I work with Jamin. Before I joined the Chugh firm, I worked at a real estate firm during that time, so that's where the interest in real estate transactions came from. And I've had a great almost 2 years here, looking forward to many more. I'll let Hafiz introduce himself too.
Hello, everyone. This is Hafiz. I'm at the New York City office. I joined the Chugh firm in September of 2019. I've been practicing for a while now, mostly immigration, but I've done a good amount of real estate, some litigation, leasing work, and other general practice matters, but mostly immigration. But I do have also other real estate experience. I've been like somewhat of a developer as well, and dabbled in a few other things in terms of brokerage and real estate sales and things like that along the past years. All right, so today we're going to be talking about commercial real estate transactions, and we wanted to start off with the life cycle of a commercial real estate transaction. So basically, everything starts off with a letter of intent or a memorandum of understanding. Thereafter, it goes to a purchase and sale agreement that's drafted and negotiated between the parties. Along the way, some due diligence work is completed, and subsequently, even during the process of the purchase and sale transaction, there's a continuing due diligence. Then we go to pre-closing and the closing, and then there's some post-closing matters. Okay, Sheena?
Thank you, Hafiz. Moving on to the letter of intent or memorandum of understanding, the terminology differs depending on your jurisdiction. In Georgia, we generally use a letter of intent. This is a non-binding document that lays out the material terms of the agreement. So I've listed here some of the material terms that you might see in a letter of intent. So you'll see the parties' names, the property, purchase price, due diligence period. But the point of it is to make sure the parties are on the same page before they go into the purchase and sale agreement phase, simply because it creates less chance of confusion. It makes sure you're in agreement about material terms and you're ready to just move forward efficiently.
Okay, great. Thank you. So the purchase and sale agreement, that's going to become the governing document that'll lead the way in terms of the transaction, how the transaction is handled, and it sets the stage for the steps in between that are involved in terms of reaching the closing. The purchase and sale agreement, the LOI, MOU, sets forth the parameters that should be reflected in the purchase and sale agreement, the PSA agreement. We hope that most of the business terms are completed by that time. Sometimes they aren't, and then there's still continued negotiation. But provided that most of the business terms are done, then it's more of a legal back and forth between the attorneys to work out the final terms of the PSA. The PSA tends to be generally seller friendly. You also want to obviously even it out as a buyer to make sure you get some of the points that you want covered. All right, so with that preface, let's jump into the purchase and sale agreement, please.
So the way we're going to frame this is when we talk about a provision, we're going to talk about the buyer's goals with respect to that provision, the seller's goals with respect to that provision, in an ideal world, and then what actually ends up happening or what happened in the case of this contract. Included assets. The buyer is going to want to, of course, receive as many assets as possible, including contracts, IP rights, office equipment, point of sale systems, whatever the buyer can get their hands on. The seller will generally want to minimize assets, but is usually willing to give away what they can. So the seller has contracts of their own, and they often have leased equipment and stuff like that of their own. So it's really not possible for them to give away all of their assets. That being said, what ends up happening in reality is it's usually a pretty fair deal in the sense that the seller will convey what they are able to convey in the sale. And then if there are contracts or leases and that sort of stuff, the seller will go ahead and assign those rights to the buyer. So really it ends up being pretty even ground, and it really just depends on the quality of negotiations and the bargaining positions of the parties.
All right, great. So excluded assets, just as the title suggests, these are assets that have been excluded according to the agreement of the parties. These are assets that will not be sold or transferred to the buyer. So obviously, from a buyer's perspective, the buyer wants the maximum number of assets that it can get its hold on. Conversely, the seller wants to minimize what it sells and transfers out. And so these are very important factors, especially from the seller side. They want to make sure that any assets that they do not intend to sell are set forth here, or in other ways are not potentially included. So in this particular case, for example, the corporate seals, charter documents, minute books, etc., as you see on paragraph 1.2, they're expressly excluded. Also excluded here, interestingly, are some of the copyrights, trademarks, trade names, logos, and slogans. These tend to be included usually in the purchase and sale transaction, but in this particular case, this is what the parties wanted, and then they set forth this provision and they agreed to it. So at the end of the day, it's a matter of negotiation, what the parties want, and that's what gets settled in the contract. Okay.
Great. So we'll move on to assumed liabilities. The buyer's, of course, going to want to minimize the liabilities and assumes as much as possible. That being said, the buyer will usually take on matters that arise from closing date on. The seller will want to pass on as much liability to the buyer as possible, especially because they're usually in the position where they just want to wash their hands of this property and move on to their other business matters. So they'll want the assumed liabilities to be as expansive as possible and to fall on buyer. What usually ends up happening is the buyer assumes all liabilities from closing on. But normally I would recommend that buyers should always argue that they should just assume liabilities from closing on.
All right, great, thank you. So the allocation of purchase price. So this is, again, something that's negotiated between the parties. It has impacts mostly on taxes and potential tax ramifications in the long run, and potentially also in the short run in terms of sales taxes. So from a buyer's perspective, buyers, for example, in New York would pay the sales tax with respect to the sale of any equipment or any other tangible assets that are subject to sales tax. From a seller side, they're looking at taxable incidences of selling, let's say, goodwill versus the lease or some other asset. So these are negotiated. I usually tell my clients that speak to a CPA, decide based on your circumstances, specific circumstances, what is the best allocation that works for you and saves you the most in terms of expenditures and potential tax incidents down the line, and then we'll go based on that. So it is negotiable, but it depends on the parties. They'll decide.
So the allocation also serves to help the lender and the title insurance company figure out how much they want, how much money they need to put in to back the property in question.
Okay, great.
The next provision we'll talk about is due diligence. But in terms of the purchase and sale agreement, what you want to do with due diligence is you want to make sure you have enough time as the buyer to complete all of your exams, reports, get your assessments and evaluations, and have time to review and ask seller to cure any defects that you find. So the buyer is going to want to make this a longer period of time. I have received requests from buyers if they can waive due diligence altogether and just proceed to closing. And that is certainly an option. I don't recommend it, only because the liability you face when you find out something after the fact is going to be much greater than if you just address it during due diligence and have the seller help you out with that cost. So that being said, the seller is usually going to want to make due diligence as short as possible. And they generally tend to be very cooperative in providing due diligence documents. So they'll provide their title insurance policies, their surveys, their environmental assessments. So you have time to look through all of those documents and decide which reports and assessments you want to request yourself as the buyer. The length of the period itself varies by contract. It really depends on what you need to do and what you want to do with the land. If it is just ground, bare ground, there is no building on it, and you tend to build on it, you'll have to do zoning reports and that sort of stuff. So for that reason, your due diligence period will usually be no less than 120 days. If you're not dealing with zoning issues and you're just doing your basic reports and stuff, I recommend a 60-day due diligence period, but you can go as low as 30 if you want to close faster.
Next section is limitations on inspections. So this paragraph, again, is negotiated depending on the nature of the transaction, what's involved, what type of inspections may be involved. In this case, I believe this was a gas station and some properties. So there may be situations where the buyer needs to break, let's say, a wall or a small section, or do a core sample to check for leaks or some other engineering related inspection. So this particular provision here requires the buyer to restore whatever changes that they may have made in connection with the inspection. And also here it's provided that the buyer cannot speak to any of the employees or contractors or others on the premises of the seller. The point being not to disrupt or interrupt the business as it stands. Also, the buyer is required to take care not to cause any harm or do anything that will cause a cause of action or some other liability for the seller. And I believe elsewhere there is a requirement that the buyer maintain insurance to cover for potential situations like this that may come up. From a buyer's point, again, we want more rights in terms of what we can inspect. We would like to potentially speak to employees or others that work at the premises or maybe there. We'd like to have expansive rights with respect to the physical condition of the property. Engineer may want to pull down some tiles to check something. So obviously we want expansive rights, and we also may want to have some representations related to that. But again, it goes back to what's negotiated, what's agreed between the parties. And here, this was the agreement, and that becomes the case. That's it. You have to be bound by that at this point.
Okay, we're gonna just representations and warranties of seller. The buyer's going to want to maximize seller's representations and warranties because they want the peace of mind to enter into the transaction. They want to know that the seller is going to stand by the business and the property, and that seller has conducted itself in an appropriate manner when it comes to compliance with laws and that sort of stuff. So the buyer's going to want that to be maximized. The seller, on the other hand, is going to want to minimize them or make them as boilerplate as possible. They're going to want the buyer to rely on the buyer's own due diligence and research that the buyer has done in order to minimize its own liability. Where possible, the seller is going to want the buyer to take everything as is, and again, to rely solely on the buyer's own due diligence. What ends up happening in reality is these tend to be very boilerplate.
Representations and warranties of buyer. As Sheena mentioned, each side obviously is looking out for their client. As a buyer's representative, I'm looking to minimize representation that my client will make. I want to minimize the potential ability on the part of seller to later find that we've violated a provision and then give the basis for some other cause of action or to withhold or forfeit our deposit. Notwithstanding, there are certain boilerplate requirements that are usually common, such as the organization, the entity that's involved in the transaction is in good standing, that the individual who's going to ultimately attend closing has the authority to complete the transaction, to enter into the transaction, that there are no other conflicts or other consents or other prohibitions with respect to the entity or the individual entering into that. Also, that there aren't any legal proceedings. Here, also, this provides that the buyer has the funds and the wherewith to be able to complete the transaction. There is a representation regarding brokers, the idea being that you don't want another broker suddenly coming in down the line saying, I created, I led to this transaction, I created a meeting of the minds, and then potentially have a claim to a brokerage commission.
The next sections I want to cover, that's the transition and transferred employees section. Although this isn't really litigated that often, it is negotiated pretty heavily, just because when a buyer is assuming a business, they're going to want a transition period. They're going to want the seller to keep some people on board, or have a few people who hang back, who can show the buyer the ropes, and kind of keep business going as usual until the buyer assumes full control of the business. The seller tends to be willing to do that, although for not for very long. I would say 2 to 4 weeks at most. At that point, the seller will take out its management, employees, whoever is actually assisting the buyer with conducting the business. In this case, the seller was willing to do a transition period. Like I said, the parties have a great relationship and they do buy and sell from each other fairly often. So in this case, we had the employees had the ability to stay back and continue to work for the buyer. The seller also assisted with transferring point of sale systems, utilities, even liquor licenses, lottery licenses, all of that stuff as well. So usually if you talk to the other side about it, whether you're the seller or the buyer, you'll be able to work something out. The next provision we're looking at is casualty, loss, and condemnation. A casualty would be some sort of natural disaster that destroys a portion or all of the premises, whereas condemnation is usually done by the state or the jurisdiction that the property sits in, where a part of the property or the entire property is deemed unusable and sort of seized by the state, in which case the record owner, the owner of record in the clerk's office, would receive some kind of credit for the taking. Usually how this would work is the buyer would want some sort of relief if there were a casualty or if there were condemnation. For example, they would want a reduction in the purchase price if a part of the property was rendered unusable, or they would want part of the credit for the condemnation. The seller will obviously want to keep all of that money. They might want to just terminate the contract and just call it a loss and just take whatever proceeds they can get and just hold on to that.
Next, I think where are we at? Confidentiality. So this is a pretty straightforward provision for this kind of transaction. In other technology or other type of transactions, it's probably going to be many more pages and pages of provisions and representations. But in this case, it's fairly standard. This basically provides that both sides will keep the details of the transaction confidential. They are also obligating each other, mutual reciprocal obligations to keep records regarding some of the assets and tax records and so forth, in case, I guess they're thinking that if there's problems down the line, that they will have these records available. Conditions to close for both buyer and seller. So these are conditions precedent for the obligations of each side to close. So basically, these provisions set forth the circumstances under which one side may not need to close in the event, let's say, there's a misrepresentation, if there's sometimes a change in circumstances. What are the requirements at closing? Here, the seller is required to deliver a certificate of seller, a bill of sale, title searches, providing that, all the assets are free and clear, or whatever other conditions may have been agreed to between the parties. Same things on the seller side. Seller would want to make sure that the buyer has not misrepresented, has not done anything inconsistent, has lived up to its obligations with respect to prerequisites prior to closing. Provided that everything is in order, then the conditions are met. The parties can then proceed to closing. Here, I wanted to note that sometimes in these asset transactions in New York, for example, we also run a state sales tax search, and we request clearance from New York State from sellers' payment of sales taxes. So sometimes we'll wait for that. If we don't receive that, we'll have a condition that we're going to escrow certain funds and hold them until we receive such clearance, just to make sure that there aren't a lot of sales taxes due on the property, on the assets or the business itself, for which there may be a lien that is due against some of the assets that our clients are purchasing. All right. So again, generally here, these are the obligations of both sides in order to close.
Great. The next section is that's closing costs and prorations. Generally, each side bears their own closing costs, but I want to look at which is transfer taxes, and that could differ by jurisdiction. How they'll want it to play it out is the buyer is going to want seller to pay that transfer tax. It tends to be quite a bit of money. For reference, in Georgia, it's $1 per 1,000. plus 10 cents per 100. So it could end up being thousands of dollars that you have to pay in addition to your closing costs. So the buyer's just going to want seller to take one for the team and just pay that money. The seller obviously is going to shift that cost to the buyer. Generally, the way it works is the seller is liable for it. If it is unpaid, that liability would fall on the seller. However, seller usually contracts that responsibility away and has buyer pay that at closing. So there's no chance of liability, and that money gets paid directly to the county. It's not really for either of the parties. It's simply so that the seller can transfer the property of record to the buyer.
Great. Now we go to default and indemnification. So these provisions here are fairly reciprocal on both sides. They're mutual mostly. However, if you're on the buy side, you certainly want the seller to be on the hook if there's something that you discovered a year later that wasn't discoverable, earlier on. So certainly, you have to weigh the pros and cons and see what you can get. But generally, you don't want too many things to survive, especially if they're against you. I think that's it in terms of the survival, Sheena.
Right. So very quickly, the last thing to note is, and this is a general point regarding termination options, and buyers going to want to secure as many ways to terminate as possible and receive a refund of its earnest money, whereas seller is going to want to minimize the buyer's right to just terminate at a whim. So usually seller is going to want to limit that to buyer can terminate before due diligence ends for no reason whatsoever. And then after that, buyer can only terminate if there is a default by seller or if the property is condemned. And that kind of wraps up our review of the contract, but we do want to take a few minutes to run through very quickly the remaining stages of the closing process. Due diligence is such an important area to cover because this tends to be where deals fall apart. But when it comes to due diligence, there are some things that sellers are not willing to fix and buyers are not willing to move forward with. So some due diligence action items would include a title exam. So you would just run title on the property. The point is to go back at least 50 years and make sure that the property changes hands in a valid and clear way. So you want to make sure you know where it's been for the last 50 years, who's had it, if they've partitioned it or did something strange with it that would affect your property rights at a later date. The next thing you'd want to do once you receive your title exam is you want to draft up your title objections, which is buyer saying, I saw this, this, and this in my title exam, and I don't agree with these things, so seller, I want you to fix it. And those objections must be raised in the time period permitted by the purchase and sale agreement. If it is not, they are waived, and buyer just has to live with those defects and decide if they want to move forward or if they want to just walk away. Also part of that, hand in hand with that, is getting seller to cure those title defects. Normally, if it's something that seller has caused during its time as record owner, they will just go ahead and take care of that for you, or at least give you the documents you need to take care of it. The next thing is a survey, wildly important. Most lenders will require a survey on the property, an updated survey. So most surveys are only valid for about 6 months. That being said, a lot changes in 6 months. If you're dealing with a commercial transaction, especially if you're building improvements, or, the city decides that it wants to put a sewer line somewhere. So a survey will show you your property lines, your boundaries. It'll show you easements, right-of-ways. It'll show you interests that are shared with other people. It'll show you if there's an encumbrance. Perhaps you built a fence that goes into someone else's property. It goes beyond your property line. So those are things that would have to be fixed in due diligence. Your next thing is environmental assessments. So these are phase 1 reports and phase 2 reports. These are enormously important if you have just ground, so there's no building or anything on it, and if you are looking at a property that either conducts some kind of business that involves toxicity to the environment, for example, a dry cleaner or a gas station, or if you have a property that's surrounded by those types of businesses, you'll also want to do an environmental assessment. It's also important to do them if you're near running water. A lot of counties and states will have restrictions as to what businesses you can run near running water and how far out you can build into them. So you want to make sure that the ground, the soil is good, the water is good, and that the business or land you're planning to buy did not pollute anything. The next thing is insurance. You want to make sure that the property is insurable. And the building is insurable. So you should look into that before closing, because the last thing you want is to close and then find out that for some reason, these well-known reputable insurers are not willing to give you liability insurance or business interruption insurance or whatever type of insurance you need. The next thing is permits, licenses, authorizations. So many of our clients deal with lottery, beer and wine, liquor. All of these things require some sort of permit or license from the state. So in order to get those permits and licenses, the buyer itself needs to fulfill many requirements. So it needs to be in good standing. It needs to provide financials. It needs to do X, Y, and Z, fill out a personal guarantee. So another thing is zoning, which is really important if you're planning on building on bare ground. Zoning usually isn't an issue if you have a property that has a building already on it and that building has been operating as a commercial business for many years. Chances are somewhere along the way, someone did the zoning stuff properly and has the reports to back it. But if you have bare land, or it looks a little bit like an area that could be residential or commercial, you want to go ahead and get a zoning report and make sure that it was zoned properly. Next thing is an appraisal. A lender will generally demand one of those. The last thing is the lender and title insurer requirements. Your lender and your title insurer are going to want certain things. So a title insurance company is not going to cover defects in a survey if you don't give them a new survey report. So for that reason, you need to discuss with the lender and the title insurer whether they have any requirements to issue a title insurance policy or to grant the loan. It's also up to the buyer to do their own due diligence separate from what work the attorney is doing. For example, the buyer is going to want to review the seller's rent rolls if the seller is collecting rent from its tenants, to make sure that the seller isn't offering, perks to some of the tenants on the property, which actually ends up undermining the value or undermining the purchase price that they have for the property. You'll want to look at sales history. You'll want to look at whether there are liens, judgments, anything like that against the property or the business, or against the seller himself, whether personally or as an entity. So those are all things you're going to want to take into consideration, which explains why due diligence usually cannot be done in less than 30 days.